All right, well, welcome everybody. We'll have folks that will be continuing to come in. We'll go ahead and do introductions and get started. Thank you, everyone, for being here, and thank you, Sean. Really excited about this. This is part three of our self-employment series for the psychedelic industry, geared for those of us that are individually employed or just want to gain more knowledge of how we can better understand the industry, and make sure we're staying in compliance and just functioning better as organizations. So today's issues will be around legal affairs and legal issues, specifically for the psychedelic industry. Really pleased to have Sean Clancy here with Emerge Law Group. They are Emerge and Sean are all huge supporters of the psychedelic industry and the Psilocybin Assisted Therapy Association. My name is Jason. I'm the co-founder of Psilocybin Assisted Therapy Association and the business officer. So today, when Sean gets started here in a few minutes, we'd like to ask that we keep conversations in the sidebar at a minimum. If you'd like to have a conversation with somebody, feel free to do that through direct messages. Throw in questions that you have, depending on the relevance. I will ask questions either directly to Sean during it, if they seem pertinent at the time, or otherwise we'll hold them towards the end, and then Sean will manage the Q&As throughout it. Do ask that no discussions around substances be discussed, either procurement or use of them. It just helps us keep the YouTube channel safe and our focus on the outcomes that we have. Do ask everybody to be respectful about others' opinions, that this is, a broad industry and all of us come with different viewpoints. Let's respect everybody's viewpoints. And we won't be getting into subjects that are really off topic. We can always do that later, after the recording ends. At the end, there will be the Q&A session. If you don't feel comfortable asking on record, we will stop it and keep the conversation going afterwards. So if you'd like to ask a question then, and Sean's is available for answering questions there. So with that, we'll say that Sean's information that he's providing is around, the legal aspects. He's not a tax professional or knowledgeable around other. He might be knowledgeable, but we're not going to be discussing other topics. So this is going to be around what the legal affairs are and legal issues. I do encourage you to find other information or watch our other videos if you're interested in insurance or tax or OPS licensing fees. And with that, I'll pass it over to Sean, and thank you very much for being here today.
Yeah, thanks for having me, Jason. Hello, everybody. As I get started, I wanted to invite everybody just in the chat. It would be helpful for me to understand who you all are. A couple of you have already introduced yourselves a little bit, but if you could just drop a little bit, maybe just your background, if you have any sort of other educational background or other licenses or activity in as a medical provider or mental health provider. And then also, if you're seeking or have a current license under Oregon's Psilocybin Services Program, if you're applying to be a facilitator or already are, or if you're part of a service center, any of those things, that'll just be helpful for me to know how acquainted you are, or if you're not those things too. Because my presentation today is really focused on some blocking and tackling business basics, but especially focused on Oregon's licensed psilocybin program. So if you please could just drop those in the chat as much as you're comfortable sharing. That'd be great. So let me just get my presentation. So yeah, legal affairs. Again, specifically under Oregon Psilocybin Services Act, which creates this licensed program under Oregon state law. What we have here is a map of the state of Oregon. The counties and cities in red are places that have opted out of allowing psilocybin services to be licensed within their borders. The green spots are places within the state of Oregon that do allow this licensed business to occur. So yeah, it's not just available everywhere in Oregon. It's only within these places, at least under the license program. This comes from a website called Psychedelic Alpha. We help produce this map there and keep it updated as people, different states and counties opt out or opt in. This probably goes without saying, but I'm a lawyer. I'm not your lawyer. The information in this presentation is just for educational purposes. I'm not creating an attorney-client relationship with any of you just by virtue of this presentation. So if you have specific legal advice about specific legal issues, I ask that you get help from a lawyer who can really understand the whole situation, whether that's me or somebody else, because you can't just kind of off the cuff some kind of serious legal questions. So I don't like to do that. Um, so where are we in Oregon legally? In 2020, both Measure 109 and 110 passed by voter initiative. They're both pretty substantial majorities. Measure 109 created the licensed psilocybin services program to be administered by the Oregon Health Authority. That's what I'm going to be spending most of my time today talking about in this presentation. Measure 110 also passed. That was known as the Drug Decriminalization and Addiction Treatment Initiative. That's what decriminalized small amounts of all drugs for personal possession under Oregon state law. So small amounts, personal possession. Commercial drug activity was still a crime. This has now been rolled back, and starting within a week, the rollback will be effective. So those possessions will be misdemeanors again. So with regard to psychedelics, that just sort of leaves Oregon's license program for psilocybin services. So what does that do? That creates many. So many of you are maybe applying for these licenses. So I'm going to try to be quick in terms of roughly describing Oregon's psilocybin services program, but it creates these 4 license types: manufacturer, laboratory, service center, facilitator. Manufacturers where psilocybin mushrooms are grown and can be processed with the right endorsement into other types of products for ingesting. The laboratory tests them. There's currently only 1 lab licensed. There used to be 2, but now there's only 1. That's perhaps an issue for the license program. And then service centers. This is where the client, not the patient under the program. It's not a medical program. The client purchases psilocybin products and consumes them and experiences the effects under the supervision of the licensed facilitator. And then the facilitator is the person who gets the license to supervise the session. They get trained at approved training programs. So the training programs themselves are not reviewed in detail exactly by the Oregon Health Authority, but their curriculum is approved, and they're licensed also by the Higher Education Commission, HECC, something like that. It's an Oregon state agency that also supervises all other kinds of places of higher education and professional training to make sure that they're not swindling people. So that's to keep the training programs in compliance with these kind of educational program laws. And my slide, there we go. So that's Oregon's program. Zooming out, so we've been talking about this program under state of Oregon state law. The state of Oregon has its own Controlled Substances Act. That Controlled Substances Act is different and in conflict with the Federal Controlled Substances Act. So we exist in a world where there's a conflict between state and federal law. This creates a bunch of big legal issues because of the federal state law conflict. There has not been an official response from the United States Department of Justice. The United States Department of Justice, that is the office within Oregon that would prosecute violations of federal law here, should they choose to in their discretion. Oregon Health Authority has asked for comment and feedback from the Justice Department. As far as I've heard, their comment is basically no comment. They're aware of what's happening. And that's about it. That's what they have said. They're not going to try to paint themselves into a box in terms of what they're promising or not promising to do. So I think they're just taking a wait and see approach. It's very similar, perhaps, to what happened with marijuana as marijuana became legalized in different states. I've got a special experience with this. So I've been a business lawyer practicing with marijuana companies for over 10 years. I mean, that's my day job. I'm a general business lawyer. I work with all kinds of businesses, but especially these controlled substances businesses. And by virtue of my participating, I worked with Tom and Sheree Eckert and my colleague Dave Kopelak to draft Measure 109. So I've got kind of particular insight, I think, that I bring to the table and could offer, and happy, like sharing with people about so where this puts us. So we've got this sort of new state federal legal conflict, similar to cannabis insofar as it's a controlled substance. I think there's a lot of differences though, but anyhow, that's puts us where we are. The Food and Drug Administration has the ability to regulate food and drugs. They have not made an official response to DEA. There is a battle going on in Washington State under federal right to try laws. That's gone up and down the Ninth Circuit. My colleague, Catherine Tucker, is leading that case on behalf of a patient who's dying and trying to seek use of psilocybin as part of her palliative care under the supervision of her doctor. It's under a different law. Um, but that is kind of would not change sort of the organs program. Organs program is operated under the state license, notwithstanding federal conflict program. So the DEA is having that battle with Dr. Agarwal is the doctor in that case, and with Catherine Tucker and his patient, but they're not making it. They haven't made any official response to what's going on in Oregon. Banking, every bank is deals with a bunch of federal agencies that govern finances, and as a result of that, they are most do not openly bank with psilocybin. I'm aware of one that if you email me, I can send you what I know. I prefer to receive emails. I don't, since this is being recorded, I don't want to put out false information that might change over time. I guess this is dated, August 27th here, but if you email me, I can let you know what I know about banking. But generally, it's because of the violation of federal law, banks don't want to risk losing their charter dealing with psilocybin companies. Federal trademarks are not available. So if you're trying to start a national brand, you're not going to be able to get a federal trademark. Federal trademarks are only granted for federally lawful commerce. So that means if a service center or a facilitator or somebody operating under Oregon's law who wants to become a national brand, they just kind of don't have that sort of ability because that's just how it works with U.S. federal trademarks. Bankruptcy. This is also a big one if you're entering the space. We, I guess, haven't seen a case with facilitators. A lot of the precedent, again, comes from cannabis. And so I think this would likely apply for service centers, but facilitators are a little different because they're not touching the mushrooms, whereas service centers definitely are touching the mushrooms and they are trafficking. So whether or not bankruptcy would be available for facilitators, I'm not sure. But what has happened in cannabis, because bankruptcy protection is a creation of federal statute, you have to go into federal court and ask for relief from your debts. And it's something that federal judges will grant people if they say, okay, I'm a business, but I can't pay my debts. And then you can go through the federal bankruptcy process. That's an equitable power that courts in multiple cases, and you could probably predict this is what would happen in psilocybin, is they would say that, we can't use our federal legal power to enable, and for example, doing things like selling off assets to resolve the debts. Something they normally do in bankruptcies, you just like sell off assets and start paying off creditors. The federal court is not willing to do that in the case of a business that's violating federal law. And that's what we've seen in cannabis. So they basically force cannabis companies, and you would expect that a psilocybin company facing bankruptcy, they would have to figure out other ways of resolving their debts that don't include going to federal court with the federal bankruptcy process. So that's a big thing to be aware of if you're getting into the service center and going into debt, is that, have a plan for if you aren't able to discharge these debts, you can't just declare bankruptcy. There are state law kind of similar analogous processes, but they're not quite the same. But there are state level things that can be done to sort of work with creditors and try to avoid, that sort of situation. But it's not the same federal bankruptcy process. And then the big one, I understand there was already a presentation about tax, so I won't spend too much time on this, but this is also just a huge issue that does affect how people are structuring businesses and decisions they're making about how they're aligning their business, and that's 280E. It's an IRS taxation. Because psilocybin is a Schedule I drug, it's subject to 280E, specifically anybody who's trafficking. And that's really the key, is if you're trafficking or not. And people have different opinions about what rises to the level of trafficking. We don't have a case saying for sure what is trafficking, what is not for psilocybin in Oregon's program yet. We can be pretty safe to say that the service centers are, because they're buying and selling it, buying it from manufacturers, selling it to clients, are the facilitators. That's not entirely clear. I think there's a good argument. There's a good argument that they're not trafficking because under the regulations, they're not allowed to touch it. But not touching it is not kind of the end of the story. I think there are different tax professionals who have different opinions and different legal arguments, and it would really be up to the IRS ultimately. I think, again, there's a good argument that you're not, but we just don't know because we haven't seen that case for sure before the IRS. But so what this does is if you're trafficking, 280E, as Internal Revenue Code provision, prevents deductions. So you can still have cost of goods sold, but you cannot deduct your ordinary necessary business expenses. And this can add up. Again, I trust that you've gone through this with one of the other presentations, specifically focusing on tax. But basically, it means that if you look at my graphic here, the business on the left is not subject to 280E. They can deduct all of their regular business expenses. They also are not taxed on the cost of goods sold. So their amount of taxable income is lower than the business on the right, even though they may have the same cash flow otherwise. The business on the right is subject to 280E. They still get their cost of goods sold if they can prove that their cost of goods sold, but as far as deductions, they're taxed as if they still have all of their regular expenses. So even if they've so they take in, X amount of revenue and then they pay money that would ordinarily be an expense, a business expense, and then they'd be taxed on what's left. That's what would normally happen. With 280E, you're taxed on that money if you're trying to claim that they're expenses. So it's a big, big issue. It can become it can result in a very big tax liability if you're not aware of it, or if you're following it. And so there's lots of creative tax professionals working on solutions to how to structure businesses to try to minimize this effect. Again, I'm not going to go into that too much here, but it's presentation purposes here to sort of flag these big issues so that you're aware of them and asking about them. If you're seeking advice from different people, just you need an accountant if you're running a service center and you want them to nod their head when you ask them, okay, what do you know about 280E? You don't want them to ask you what is 280E. If you're talking to an accountant who doesn't know what 280E is, you might try to look for somebody else, honestly, if you're in starting a service center or starting to work with psilocybin here, because it's really could have serious long-term consequences for how you calculate your tax. So speaking of Oregon's program and some of the how it's developing, I think it's useful just to keep an eye on what's happening and what are the current market conditions. So as of yesterday, there's 13 manufacturers, there's 31 service centers, there's 356 facilitators, and there's one lab. I understand there's lots of different locations and types. I'm personally very interested to see how all of that develops, but I think there's room for a lot of creativity. The program, not being medical, strictly speaking, allows people to enter it for any purpose as a client, and so long as they're going through at a licensed service center with a licensed facilitator, getting licensed product from a licensed manufacturer, so long as they're within that program, I think there's room for creativity. We'll sort of see how it continues to develop that. So just some really basic, important concepts are really applicable to any business, but things to keep in mind for whether you're a facilitator or a service center, or both. The first one is having an organizational structure. Oftentimes this is a limited liability company. It can also be a corporation. There are nonprofits out there as another type of organizational structure. But I mean, there's a lot of advantages to having a legal structure set up to operate your business through. And folks who've operated in other businesses would be kind of familiar with some of these. But the really big one is insulating from liability. If you set up a business entity and operate your business through that, you can preserve some amount of liability protection. So, for example, if you enter a lease in the name of your limited liability company. It's like not Sean Clancy signing on the lease and guaranteeing to pay rent. If it's Emerge Law Group entering the lease, and Emerge Law Group is then the one who has the contract with the landlord. And if the rent isn't paid, the landlord can't come after Sean Clancy as long as I've maintained my personal legal formalities. The landlord can go after Emerge Law Group and its assets. I still don't want that. We're still going to make sure that we're paying our rent, but it's nice to know that, if there was a colossal problem that I would not personally be liable for things that my limited liability company or my corporation or my business entity for the activities of the business entity. And so it's just a good idea. And it also has a bunch of advantages in terms of accounting and keeping things organized and doing your annual taxes, like having it in a single bucket for your facilitation practice or your service center. It's a really good idea. Related to that are tax classifications. Again, I won't go too deep into tax, but there are different advantages, especially given that this is a controlled substance and there are potentially hefty tax consequences of if you miscalculate your 280E liability, if you take a riskier position. There are ways to protect from that. And the big one is sort of deciding whether your tax is a pass-through entity, where your taxes pass through to your personal return. That also means, however, liabilities, if you miscalculate it, could also pass through on your personal return. So one way to avoid that, if for people that are very concerned about their tax situation and maybe taking riskier tax positions, or even if they're not taking riskier tax positions, they're just kind of more careful and conservative, and you're just really not sure about how things are go. There's also corporate taxation, you can be taxed as a C corporation, which is not a pass-through entity, and that prevents tax liabilities from flowing through. So we get limited liability for tax issues. So that's something else that can be done under a legal entity. So again, another reason why it's a good idea to have a separate entity. I talked a little bit about the variety of service centers, and I think the variety of facilitator practices too. Yeah, I think it's still unknown for certain whether facilitators will be considered trafficking, but the service centers likely are. I think you because this 280E tax liability and getting taxed on money you don't have, like what a horrible concept. Avoiding that, one way to do that, and I think this is also something to do working with an accountant and also a lawyer, is you can potentially look at whether there are separate lines of business. So Oregon's program, when you get down to it, okay, the psilocybin services are the preparation session, the administration session, and the integration session, and those are they're very kind of constrained actually activities that can be limited to a certain period of time and a certain amount of that's just it can be constrained, and then you can do lots of things before and after those, which is one way to start thinking about, okay, are there other lines of business? Can you take a position with a straight face that maybe there are other lines of business? This is again something to work that's very specific. It gets into the exact details of, you can't just have a couple shirts hanging up in the front porch and say, okay, yeah, we're a retailer. That's a little too cute. The IRS will say, no, you're just selling swag for your psilocybin business. But maybe if you had an entirely separate premises that was not licensed, and there was actually some revenue coming and going, and there was some traffic there was like an adjacent business where something really was happening. There really were there really are yoga classes going on in a room that's different from where everything else is happening. You could start to see how there could be a case. And again, very specific, not off the cuff advice here, but thinking about, are there ways where there could be a separate line of business that's not trafficking, or just even as a part of the business model? I think, and there's interesting creative things that can happen because of, I think the uniqueness of psilocybin and psychedelics, but also being driven by some of these tax issues and some of these business issues too, having maybe there is a straight-faced argument that there's a variety of wellness services happening before and happening after the psilocybin services, and I think that's where there's juice to squeeze perhaps to help with those issues. Digging in a little bit more into the the rules of the program. Um, so one of the big kind of frustrating and controversial issues that's actually different in Colorado. In Oregon, the scope of practice for facilitators during the psilocybin services, during preparation, during administration, and during integration, the session where you're preparing the client, where the client is under the influence, and then after, with the integration session that has to be offered. The regulations prohibit practicing another licensed profession during those times by the facilitator. So there's ways to think about, that can be frustrating for somebody who's got another licensed profession and they want to be practicing that profession during the session. And the rules prohibit it. The amendment, I'll just skip to the next slide for a second. This is a proposal. These rules are still in draft form today, August 27th, 2024. So this has not been approved yet. But you'll see the first rule has not been proposed to be changed, at least by the Oregon Health Authority. They're prohibiting diagnosing, treating mental, physical, or prohibiting diagnosing or treating physical or mental health conditions during the psilocybin services, which does mean, though, specifically during preparation, during administration, during integration. Theoretically, somebody who has professional licensure could do those things before, they could do it after. That's not prohibited. It's just during the session, they're prohibited from doing that. If you're a psychologist, query how you can do that, especially if your client is also your patient. That's a complicated question. I don't know how to square that, and in terms of a psychologist doing their practice, working with the patient asks them questions, how can you remove your psychology training? The closest analogy I can think of is, I'm an attorney. If I'm sitting in a bar and somebody comes and starts asking me questions about legal issues, I can say, well, I don't know, this is not legal advice. I'm not acting as an attorney right now. I think that's kind of the idea. Is you can imagine that, okay, I'm not acting as your psychologist right now. I'm acting as your facilitator. And so the Oregon Health Authority is hoping that they can kind of make that artificial legal separation, sort of say, okay, if I'm a psychologist, I'm taking off my psychologist hat while I'm acting as a facilitator. I think that's the idea, but this is kind of an interesting wrinkle. This was not in the ballot measure as we wrote it. This was a creation of the statute, or rather of the regulations of the Oregon Health Authority. Facilitators are prohibited from transferring or selling the psilocybin themselves. So I think this protects them from potentially being wrapped up in the 280E trafficking bucket, but it's not, again, certain on that issue. Oops. Scope of practice. There we go. So some other issues that are just important legal issues to spot and be aware of in terms of operating under Oregon's license program is that insurance, there is now a couple of insurance carriers available. Again, you can email me and I can send you the most up-to-date information I have. I don't want to put out of date information. My email address is in the chat and it's at the beginning and end of this presentation. And then, so finding insurance was a challenge, but it sounds like there are some. They're still not ideal policies. I'm aware that most of them are issued to service centers who then have coverage for their facilitators. I've not personally interacted with facilitators who've individually gotten professional liability insurance for acting as facilitators, but I understand that it is theoretically available. I'm not sure about the quality of those policies, though. So going through the program, most of you probably know a lot about this if you're applying to become facilitators. There's the client information form, but there's a mountain of paperwork that you have to do with your clients before going through the session. It's kind of a pain. I will say I did a recent survey, and it's been kind of encouraging to see initial results of how many people have been through the program and the sort of lack of at least cognizable legal damage that I've been aware of. It's only been a year since there have been service centers out there, but it does seem like the initial results so far, there have not been any that have risen to my attention anyway. I did a public records request for the Oregon Health Authority, asking them about complaints they received. I've talked to some of my clients about it. But of 5,000 people they estimate having gone through this program, Oregon Health Authority, as of last month when I submitted my request, they only, of the 29, okay, so they'd only received 29 complaints from people who submitted them. They did not send me any active investigations, so there's a handful of active investigations, but of those 29, only one was from a client complaining about a session. So this is all to say that it seems like, as burdensome as Oregon's program might be, I think there's a lot of care involved. And I think people are being extremely careful to make the maximum amount of safety. And like from the data that I've been able to gather so far, it does seem like safety is pretty high. And so this information form, and I think the process, the training, it's doing something in terms of keeping it safe. I think query whether it's overkill for something like psilocybin, but I think that's some kind of nice data that I was able to find out. The What the Oregon Health Authority provides the client information form, the Oregon Health Authority does not cover releases and waivers of liability, though. Those are more personal for a business, and they should be kind of customized for you and your operations. That's something that we do with clients. To make sure that, okay, they've got all these Oregon Health Authority forms. Separate from that, there's a form with the client where the client is releasing you from liability, ideally. If you want that, you're making your business deal with the client, saying, okay, this is what you have to pay me when, this is how I work, this is what my scheduling is, this is how much, how I'm available, and things like that. And so it's a little bit more of a business contract that you want with your client when you're saying, okay, this is how I offer psilocybin services. But that's something I help a lot of people with. Again, it's kind of like other businesses. I work with architects and software developers, and it's like not too dissimilar when you've got a service contract. It just, in this case, it happens to be for this unique type of service. Other things to keep in mind are confidentiality. There are some very strict confidentiality rules governing both service centers and facilitators. And so those should be disclosed, or rather, privacy policies for what happens with client data. Those are supposed to be disclosed. So being careful and being cognizant of what constitutes a client record. Client records are currently defined very broadly. So if you are a licensed facilitator or a service center, the safe thing to do will be to take a expansive view of what constitutes a client record. There's been some debate in one of the recent rules advisory committees as they're amending these rules, as we speak, and they're going to continue to do so. But some debate about, is a potential client record part of the record? And I think this is something that, lawyers deal with. We deal with potential clients, but, other psychologists and licensed professions too might also run into this. Basically, the safe thing to do is to treat them as confidential. Banking, as I mentioned, banking is challenging because of the trafficking issue. I think there's a good argument that facilitators are not trafficking. That does not prevent Bank of America from having its own personal policy to refuse service to somebody who they decide they don't want to do business with. And so that might include, and typically would include, a facilitator. If you walk into a national bank and say, oh, I'm a psilocybin facilitator, I doubt that they will give you an account. They might. I mean, banks are different, and they have different staff at the ground level. And so, this also happened a lot in cannabis, where in the early days, people are able to get bank accounts and they operate with them for a while until maybe it gets up the food chain at the bank management, and the bank management, somebody says, oh, we can't be doing this. And then they shut the bank down. So they have to go to a different bank. General advice on banking, as you're getting into this industry, is diversify, especially if you've got valuable assets. I would recommend not doing your psilocybin or psilocybin adjacent or psychedelic adjacent business at the same bank where you've got your mortgage or your investments or any of your other large accounts, because it's just, there's still a risk that they could communicate each other. It's much lower, but you definitely don't want to run into a situation where a bank tries to pulls your account because of your psychedelic work, and that's an important account. So diversify, put different eggs in different baskets is a a good rule of thumb to avoid having to close accounts at your main bank. When you do go into a bank, yeah, don't lie. Bank fraud's a crime. It's also not required that you volunteer extra information, though. There are forms that you fill out when you're applying for an account. So don't lie. You can't lie. That's illegal. But you don't have to come in and start telling them everything about your psilocybin practice. But yeah, you can't lie, and so it's just kind of an inherent risk at this point. But again, you can email me and I can send you the latest whenever I receive your email about what I've heard about banking, what other people are doing. So I also wanted to start covering some issues just to be aware of, I guess, as a legal primer, equipping service centers and facilitators to avoid potential legal liability. Even though this program is safe, there's still room for human harm, and people, clients can raise legal claims even if they're unjustified. And this is one to be aware of that can be justified or might not be, but there are claims under Oregon state law where somebody can allege financial abuse, and this is a thing that can happen where if somebody wrongfully takes advantage or money or property from a vulnerable person, so vulnerable person is defined as an elderly person or somebody who is financially incapable, unable to manage their finances, or they're incapacitated, or somebody who's just generally susceptible to force, threat, duration, coercion, these sort of vulnerable people. And so that's kind of the first thing to be aware of. There should be maybe some light bulbs going off on your head if you're dealing with somebody who's indicated, oh, I don't know how to manage my finances, or they're elderly, or they appear to be susceptible to this kind of potential persuasion. I think there's a risk here of the risk I imagine is this person coming back and the perception that they're being taken advantage of. These kinds of claims often come up in the context of actually family members of somebody who's maybe nearing the end of their life, or concerned family members, basically, who worried that somebody's being taken advantage of. So it's maybe not even the person who's allegedly vulnerable, but it can be family members who find out, oh, this person, and they're worried that they're being taken advantage of. So this is just a claim to be aware of. And so, the way to be careful about it is to just, be aware, first of all, aware of it, but then also conscientious about your dealings with this person and keeping track of, who else might be a part of their life, and basically not taking advantage of them. If you've got somebody who's coming back over and over again for treatment or something like that, you start to think, okay, is there a risk that this could be happening or not? Or is there a risk that this could be perceived as taking advantage of somebody? And so you try to avoid that situation. Yeah, and I think also, this goes to some broader questions about the client information form and client screening. Every client and service center, or rather every facilitator and every service center, you are allowed to refuse service for pretty much any reason, as long as it's not discriminatory. But you don't. So I mean, if you're a facilitator and you're uncomfortable with a particular client, I think that's an important thing to listen to, and it can help save you headache. I'll say, even as a lawyer, the clients I've fired or said no to, I don't think there's a single one I've regretted. Because some people out there are just not, we don't work right, we don't feel right, or there are people out there who just could be difficult to work with. So I'm not saying that to be clear, vulnerable people can certainly be benefited by psilocybin services, I believe, but being aware that this is like a heightened risk population, and so you're dealing with a heightened risk population, that means there are potential heightened risks for you too. Again, things that can be used to help protect yourself as a facilitator, as a service center. So this client information form, that client screening, being careful, being thoughtful, being slow with it. It's a lot of paperwork. I know there's a lot of questions in there, but making sure that people are understanding it and they're not just getting rammed through the paperwork process so they can get to the session. Being deliberate, making sure that they understand it, keeping records of these meetings with them. Having records can be your defense. If somebody's alleging, oh, you took advantage of this vulnerable person, or just a person who isn't vulnerable, well, if you've got the paper trail and the list of their written consent. You've maybe got witnesses for your different interactions. That can help save you from a he said, she said situation if somebody's alleging they've been harmed or taken advantage of. Um, so yeah, I think there's people have lots of different feelings about video and audio, but it is allowed. You are allowed to record video and or audio of psilocybin sessions in Oregon if you get the client's consent. So it's something to think about. It can be positive. Some people might also say that you can misinterpret video and audio. So it's not a silver bullet, but you'd like to think that if nothing bad happened, or certainly I have even at this point seen cases where video evidence has been helpful to prove that something did not happen, that the client misperceived basically. So I think especially somebody who's in a altered state, they having some sort of record of what actually happened can be protective for you as the service provider. Ultimately, we still don't have a clear legal standard of care. This comes in terms of malpractice, if you will, or negligence. So if I'm a doctor or a psychologist or a lawyer and I do something that is less like the reasonable lawyer, the reasonable doctor, the reasonable psychologist would never have done that. Like that actually was negligent, and the negligence, like you failed to treat a very obvious condition as a doctor. That means that the reasonable ordinary doctor would have spotted that issue and would have been able to treat it or deal with it or tried to. For a facilitator, though, a licensed facilitator is not a doctor. They're not a psychologist. I like to think of it, I don't know. I think the standard is changing over time as the rules are changing. The curriculum is changing. Different training programs have different curricula. So what is the minimum competency that above which you're exceeding the minimum standard? What is the minimum standard for, as long as you do this, you're doing enough, you're keeping somebody safe, you're not being negligent? That standard has not legally been established yet. We can start to look at where it might be, where it might happen. Where this will happen is if and when there will be somebody who believes that they're harmed by a facilitator or a service center, and they'll say, "Oh, you should have done XYZ to prevent this harm from happening to me," or if you hadn't done XYZ, I would not have been harmed. And so we'll look at the Oregon Health Authority rules for one. That sets the baseline of what facilitators and service centers must and must not do. So that's kind of there, sort of setting one standard. But we have a lot of people operating in the space who have higher standards. There's physicians or psychologists again, or people with more deeper mental health background, and their training is different from somebody who maybe practiced in the underground or somebody who's got an indigenous background and hasn't gone through formal secondary education or training or graduate school. Those people are allowed to still get facilitator license, and they're allowed to practice, and they're not committing negligence. There's some room there for, we go the kind of almost the lifeguard of the facilitator. You don't have to be the doctor. You just have to kind of be a lifeguard. You make sure somebody doesn't go too far into the deep end and drown, and pull them back if they're having trouble. I like to think of it that way, but I think this standard will evolve, and it really won't be established until we get a case where that sort of thing happens. And then there'll be a bunch of experts who probably come up and talk about, what is every facilitator doing? What are all the training program requirements? And we'll start to flesh out, what is that standard? What would the ordinary facilitator have done? Not an ordinary physician, not an ordinary psychologist, but what would an ordinary facilitator have done in that position? That will help to determine what is the standard of care, what is the minimum level of care, above which best practices are great. Best practices are important. They keep people safe. They make things better. They make your business successful. They develop a good reputation. You can help serve people and make them better. Best practices 100%. I'm not saying ignore best practices. Best practices are wonderful and important, and everybody should try to improve them all the time. But for setting the minimum standard below which you can actually be sued and lose and have financial consequences and maybe, all kinds of other legal consequences. Where is that baseline? That has not been set yet. We look at the rules, we look at the requirements of the training programs. satisfying these things. Some sort of mix of these would give you an idea of, where a typical facilitator would have to be. And it's interesting too, is the standard getting pushed up over time? Is it getting pushed down over time? This happens in medicine all the time. It's constantly evolving. Every time there's a medical malpractice claim, they have to bring in new and different experts depending on the condition, and they'll often have different opinions about, was this doctor operating in a reasonable way when they made this choice, or it did not make a choice. So yeah, I think these are going to be really interesting issues that'll just continue to evolve. There's lots of places to look. You can look at standards in the underground, standards in indigenous practices, standards in other countries where psychedelics are legal. FDA clinical trials. I was in Washington, D.C. last week talking to Johns Hopkins researchers. Their standards are much higher. I don't know if that's the standard that we're trying to establish for what Oregon psilocybin service. I mean, it certainly isn't, because the amount that it costs for one person to get one treatment in one of those clinical trials is way more expensive. And so how does the system accommodate while dealing with the economic realities? We want to keep it safe. We want a standard of care that's reasonable to make sure that people are not getting harmed or neglected, but a standard that's realistic for what this program is, and that again continues to evolve. So yeah, my big points on standard care. Best practices and minimum requirements are not the same thing. They're both important, but best practices are above. Minimum requirements, that's below those minimum requirements. Okay, you're facing legal liability, maybe fines and punishments or other sanctions, but as long as you're meeting those minimum requirements, that's where best practices start. A lifeguard is not a doctor. A facilitator is not necessarily a psychologist just by being a facilitator. Looks like I know we're getting close to the hour here, so I'm going to try to speed up a little bit. So these are the elements of negligence. So if there were a claim, a client says, "Oh, I've been harmed by a facilitator," this is what they would have to prove. They'd have to go into court and they say, "Okay, well, there was a duty, so there is a duty for facilitator." So that's kind of a check mark. If you're a facilitator working with a client, you have duties to them. Those are set out in the Oregon Health Authority rules, but it kind of depends on the situation. Is there a duty around a particular activity, and did you fail to meet that duty? That depends on what happens. So if somebody is walking around the room, you have a duty probably to make sure they're doing it safely. That duty might change depending on what kind of person it is, what's in the room, who else is in the room. You can see how all the facts and circumstances will be very different, and then whether you were reasonable in how you kind of responded to meet your duty to the client at that moment. In order to have a claim, you have to have damages. So there has to be damages. And this is also going to be interesting to see how this happens in psychedelic. They have to be quantifiable somehow. You can't just say, I had a really bad trip and my feelings are hurt, without more than that. Like, if you left feeling unsettled and you can't explain in other way, I don't know if that is damage. It has to be caused. And so say it's more than that. Say there is, somebody's like, "Oh gosh, after this session, I'm having a bunch of recurring conditions that I did not have before." You still have to prove that those were caused by the session too. So this is duty, breach, failure to meet the standard, which caused then the measurable damages. So once you get that, then you've got a theory of negligence that can hang together and is potentially actionable. And so that's where we could get to some of those issues. And so again, my survey so far, I haven't seen any cases of this, which is I think encouraging for Oregon. I think it is probably inevitable. Eventually there will be one and more under Oregon's program, but it's encouraging, at least now, that I'm not aware of any claims of negligence. But that's not to say they haven't happened, but I did some decent research, and so far I haven't been able to hear or find any. So protecting yourself from claims, just some general blocking and tackling. Client screening, again, I can't say enough good things about it. It's not even really a legal remedy. It's a lot of common sense, and I think trusting your training. And being, so aside from the cleaning, all the training, I think common sense again during client care and safety, just making sure that people are safe, making sure that people are comfortable. It's really kind of basic client services stuff. I think that can go a really long way, being accommodating to people, being reasonable. Some people are unreasonable though. That's just the reality of the world we live in. So you can also, short of doing that, written consents and waivers, these are things in addition to the Oregon Health Authority forms, having some sort of waivers and consents that address one, your kind of business relationship with your client, what your business, I mean, is in what they're paying you for when you're stopping, what you're available for, what your terms are, what you're agreeing to do for them and what they're doing, what they're in exchange promising to you. So it's a two-way street. And so having good forms to sort of protect you around that can also help protect you from claims, even against, especially when people are unreasonable, because then you can say, well, no, you signed this, I did everything I could. I checked the boxes that I agreed to in this written form. Not having a written agreement, you risk a bunch of he said, she said, but piecing together over text messages or email. What did you agree to? What did you represent to them about what you're going to be able to accomplish with them? I think that's another big one in terms of, well, going back to harm, but one thing I've been hearing too is there's like a lot of people who are disappointed perhaps by the effects. And I think this goes to kind of another deeper issue of sort of where psychedelics fit and being medical or not medical. Oregon's program is not medical, not for treating diseases or conditions. Yet there's this hype in the media that a lot of people come with expectations that, oh, I'm going to get over my depression or my PTSD or my neurodivergent, something, there's a lot of people coming with expectations, and the experiences are very different and people come away with very different experiences. And I think a lot of people I've heard that people can be disappointed, of course. And then so making sure that you're not then promising something that you can't deliver. Because if you're promising them, oh yeah, I've done this with so many people and they're none of them are depressed anymore. And then somebody goes through it and they leave still depressed, there's a risk there that you've misled this person and they've maybe paid a lot of money for this. And if they're, upset enough about it and it's problematic enough where something bad happens to them, God forbid, it starts to create a situation where it's good to have it in writing that, okay, no promises here, this is not going to treat or cure your condition. And so having that as a part of your process to, understand that, there's these drugs are not promises, at least with regard to treating conditions. Again, records of sessions can also be protective. And then insurance, I see there's a mention of insurance. So yeah, this is just a little more detail about sort of what we want to include in a release and waiver. I guess the really big thing here is that in order to be enforceable, it has to be understood. And the situation of it signing, you don't want to sign these on the operating table, so to speak. Click through is okay. The ideal situation is you're going through this along with all the other OHA forms. You're going through a waiver and release. If you want it to be enforceable, you want to make sure the client understands it. You want to make sure they've had time to review it. You want to make sure that it was clear to them, and this is actually necessary for it to be enforceable. If the circumstances of them signing their release are questionable, such as rushed or presented in a way where the client felt forced to sign something that they didn't understand, or or if they have a way of trying to argue that they didn't understand what they were signing, that waiver and release that you have to protect your activities can potentially be unenforceable. It can be attacked as being unenforceable anyway. So it really can challenge you if you're facing a legal claim. So big takeaway is using liability releases and waivers is to have just reasonable, plenty of time, circumstances for making sure that the client can ask questions and understands what they're signing. It's not to say they can't, though. It is possible to assume all kinds of risks. People sign liability forms all the time to do risky things, or even not risky things. But it's, I think it's just the society we live in is having a certain amount of cognitive autonomy and freedom of choice. I'm a proponent of that kind of thing. And so, yeah, so as a part of your process, that's what we recommend, is having a as part of the preparation session, or maybe even additional pre-preparation, to make sure that people understand the risks and not to overplay them too, but that they may or may not have this effect, may or may not have this side effect. These are some of the long-term potential risks. These are things that you can expect. So that, and also the more expectation setting you do with this stuff, you can even avoid the legal situation altogether. If people expect and understand what they're getting into. Yeah, so types of insurance, again, there's sort of a backstop to protect you if somebody does make a claim. You want to be like, if you're seeking insurance without the assistance of a broker who knows what they're doing, be aware of what you're looking at. General liability insurance covers things like slip and falls, or somebody slips and falls in a location and gets physically injured. Products liability, of course, covers the product. So if you're a manufacturer, that's where you'd be looking. If you're general liability, if you're a service center, professional liability is different. That covers liability for providing the services. So for the facilitation, which I think I saw some of the, again, you can feel free to email me. I can send you my latest list whenever you do so of who I've heard of for professional liability. But those would cover that insurance or that negligence question. Are you negligent in doing or not doing something in the services to the client? You're acting in a professional capacity with your facilitator license. Professional liability can protect that. A little bit on employment law here. There are kind of two main ways that people are working for service centers. Some people are direct employees. My understanding is this is less common. Most facilitators, or as facilitators, I should say, most facilitators are acting as independent contractors. If you're an employee, though, this is less common. But maybe if you're working in a service center but not as a facilitator, you might be an employee. But you should be clear which one you are with whoever you're working with, because they get very different treatment. The big one being that the employer can be additionally liable for the actions of their employees. So you're kind of under the same liability tent as the employer. The more, roughly speaking, employment laws, it's also very sort of specific about whether you're properly classified as an independent contractor or an employee. But largely, the more control the employer is exerting over the employee and their schedule and their work methods, the more likely they should be treated as an employee. Once they're an employee, various state rights kick in, federal rights kick in, and as an employee, withholding, paying minimum wage and overtime, workers' compensation, unemployment insurance, and so you should be getting a W-2 if you're an employee, and benefits if applicable. So the more control the employer is exerting, the more you start to get into the employee bucket. A lot of service centers and a lot of facilitators are working, treating facilitators as independent contractors, though. This is where you get a 1099 from the service center. You're responsible for your own taxes. There's no withholding going on, and the contractor can be separately liable for the activities different from the employee. The employee might so again, I think this does fit with the model in many cases, is that the facilitator is the one that's on the premises working with the client, supervising their activities. The service center is not the one, strictly speaking. The service center entity, they're selling the product, they've got a representative, but they're not the one who is responsible under the regulations and the Oregon's program for supervising the client and keeping them safe during the session. To be an independent contractor, though, you should have control of your work methods and your schedule, and you would have a contract. And oftentimes we're seeing more and more of these, and that's something else we've been working on a good amount, is reviewing these or preparing them for different people, because it just clears it all up. Are you an employee? Are you an independent contractor? Having a written contract to set that out, this just eliminates any confusion. This is just a general slide about contracts. I think my big takeaway whenever I'm giving educational presentations is I encourage people to read the contracts. They're written in the language that you understand. Some of the words that can be kind of painful to read and get through, but you'd be surprised at how much you will understand. And if it doesn't make sense to you, that means it won't make sense to somebody else. And I think it's worthwhile to bring it up and ask and clarify. Don't be afraid to negotiate. You may not, depending on the circumstances, you may not be able to get very far, but sometimes you can, especially if you're working with a small business, which most service centers are, most facilitators are. Most things can be negotiated. If they're not, there's usually not a big trouble in trying if you approach it, reasonably. But once it's signed, all portions of the contract are binding. So you want to know what you're signing and getting into. So yeah, read your contracts. Don't be afraid of them. Um, and so that concludes my presentation. There's my email there, as I promised, and I'm happy to take some questions here.
Sean, that was really great. I really appreciate it. There's so much to learn, and just thought what you provided was really a wealth of knowledge, and really appreciate everybody attending today and taking time. And this video will be available, so if you missed part of it or want to review it again, we'll have it up on our website within a few days. So I'm going to stop the recording, and then we can continue on with some question and answers at that time. And if you have to go, I really appreciate your time today. And if you can stay and want to have some conversations, please do. There's Sean's email address was also in the chat, and he's also always just great to connect with and work with. So I really appreciate your time today, Sean. Thank you very much.
Thanks for having me.